using alcohol before you were driving. And that and the marijuana contributed both to the accident and the injury of this young man. You show up late for your hearing, it's not a good start to that. You know, your actions around this crime, using marijuana and driving, and then saying, well, it doesn't really affect me. Well, if it doesn't affect you, why are you using it? It doesn't make any sense to say I'm using marijuana, but it doesn't affect me. And clearly, you know, you were using alcohol. I know your statement was that you started drinking after the accident happened because you were upset of everything that's happened during this case. I don't believe that either on your own, because you want to stop ending up here in front of me in this courtroom getting yelled at for showing up late. This really is your last chance to avoid that, because I think the next time your guidelines will be within a prison sanction. 668, the record should reflect Mr. Lundy's present here in the courtroom today. If I could have counsel put your appearances on.
For the record, Mike Roll, on behalf of the people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Lundy.
All right, and Mr. Trush, this is set for a probation violation hearing today. How did you want to proceed?
Your Honor, I've been in communications with Mr. DeLeo, and I think we have a resolution of this. Mr. Lundy would be tendering a no contest plea to counts 1, 2, and 4. Counts 3 and 5 would be dismissed. Mr. DeLeo is recommending credit for the 122 days in jail, credit for the 122 days he's already served, and dismissal from probation. The reason for the no contest plea is Mr. Lundy has a trial on the Antrim County allegations, which form the basis for the violation. He indicates to me set in about 2 weeks. We don't want the admissions here to potentially jeopardize that trial.
Okay, and what are we going to use as a factual basis?
I think the court could rely on the affidavit attached to the probation violation.
Okay. All right, Ms. Davis or Mr. Rowland?
Judge, I understand the defense position as to some of the allegations, but I don't understand why if it's a no contest plea, that would have anything to do with being gone or not a listed address. How does that impact any other pending charges?
Yeah, I mean, I would agree with that. Other than for procedural purposes, it might be easier to take a no contest plea to all of them instead of a guilty plea to 1 or 2 and no contest to others.
I just want to say that to clarify the record, John. Thank you.
Ms. Davis, anything that you want to add?
And he's asking that fines and costs be preserved as well.
Okay, did we want to move to sentencing on this today?
I think it would be appropriate given what the recommendation is.
Okay. I'm just looking for that affidavit here.
I have a copy of it.
Oh, good. Can you bring that word?
And it has the paragraphs marked.
Okay, Mr. Lundy, excuse me, have you had a chance to talk about this agreement? And so what is the sentence agreement in this case? Or what is the recommendation?
Agent DeLeo was asking that probation be revoked unsuccessfully, preserve fines and costs, 122 days jail with credit for 122 days served.
Okay. All right. So, Mr. Lundy, have you had a chance to talk to Mr. Trush about this agreement?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Lundy, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes, sir.
And that by pleading no contest here, you're going to be giving up that right?
Yes, Your Honor.
Also, although we have an agreement, I think, as to what the sentence is going to be, and I don't think I'm going to depart from that, but by pleading no contest, it could subject you to the maximum penalty on your underlying charge, which is up to 2 years. Do you understand that?
Yes, Your Honor.
Okay. With that in mind, what is your plea to the alleged probation violations?
No contest.
Has anybody threatened you with anything to get you to enter this plea today?
No, Your Honor.
Has anybody promised you anything other than what we've said here on the record?
No, Your Honor.
is it your own free choice to enter this plea?
Yes, Your Honor.
Okay. I do want to confirm just a couple things. Back on August 16th and September 8th of 2025, you were on probation here in Otsego County, is that correct?
Yes, Your Honor.
Okay. All right. And Mr. Trush, you reviewed the affidavit in support of the alleged violations.
I have.
Do you agree that if true, those would provide a factual basis for finding that Mr. Lundy did violate his probation?
Yes.
And Mr. Rolla, have you done the same?
I haven't seen the affidavit at all. None's been provided to my office.
Okay, can you take a look at that?
Yeah. Okay, I have something that's marked as a probation request violation, if that's what's being referred to.
Yes.
Okay. Is this what you're talking about?
Yes.
In that case, Judge, I have reviewed it and I have no objection. I do believe that it meets.
Based on that, the court finds that there is a factual basis to support a finding that you did violate your probation as alleged. The court will accept your no contest plea. Other than what has already been stated, Ms. Davis or Mr. Rolla, anything regarding sentencing in this case?
Thank you.
Mr. Trush.
Your Honor, I would just indicate, I think that the recommendation is appropriate in this situation. I think when all is said and done on this matter, Mr. Lundy has spent about 11 months in the county jail between the sentence on the initial charge. I think we had one prior violation to this, which again, he served additional time on. And then he spent, I think, about 4 months in Antrim's jail when the new charges came and the violation warrant came down. So again, all said and done, he's served a significant amount of time on this. At this point, it makes sense to terminate the probation, I think, and the recommendation is appropriate. We ask court to follow it.
Mr. Lundy, anything you wanted to say today?
No, Your Honor.
All right, I did review the file prior to the hearing today, so I'm familiar with the original charges in this case and what's gone on during the time you've been on probation. Based on that, I agree with Mr. DeLeo's assessment that there's no benefit to be gained by continuing you on probation here. I also agree with the recommendation in terms of jail time. I find it's appropriate, and I don't have any reason to depart from what Mr. DeLeo finds is appropriate, giving him his monitoring you and his knowledge of your situation. So the court is going to adopt the recommendation. The court will sentence you to 122 days in Otsego County Jail with credit for 122 days served. The court will preserve any outstanding fines and costs and discharge you unsuccessfully from your probation. You do have the ability to seek an appeal of this sentence, and Mr. you can have Mr. Lundy acknowledge receipt of this.
It's just to acknowledge that you received it in today's report. 3-4. Your records.
Sorry, the record should reflect Mr. Lundy's acknowledged receipt of his appellate rights. That's all for today, Mr. Lundy. You're free to go. And Mr. Trush, if you can just let us know when you're ready on Mr. Fick's case.
Understood. I have not seen him check.
Sure. I mean, we're early, but we can take that at any time you're ready. On the record in People versus Fick, this is file number 256938. The record should reflect that Mr. Fick's present in the courtroom today. If I could put your appearances on.
The record, Your Honor, my fellow behalf of the people.
Your Honor, Richard Trush on behalf of Mr. Fick.
Mr. Fick, were you aware that your hearing was at 9:30 this morning?
That's right.
Is there any reason why you weren't here at 9:30?
They ran late traffic. I had to come from downstate this morning, first thing this morning.
It's perfect weather out there.
I know.
Couldn't have been due to the snow. you understand that you're here for sentencing, right?
Your Honor.
And I assume you're gonna be asking the court to, go easy on you. And when you show up late for your hearing, it's not a good start to that. You understand that? And I got a letter from your employer who indicates that you're a great employee. Do you show up late for work? No. Have you had a chance to go through the pre-sentence report with Mr. Trush and talk to him about that? What's that?
I have not.
Okay, why haven't you done that? Mr. Trush.
Your Honor, I guess can we have a minute to go over the report?
Did you?
I understand what's on there, so we can proceed.
No, I have to give you a chance from a legal standpoint to go through it with him. Did you not call him, check in with him, anything?
We talked, a couple days ago?
Okay.
We talked, we communicated, but we didn't go over really. We didn't go over that.
Okay. All right. We'll take about 10 minutes, Mr. Trush, and go through that with Mr. Fick. Okay, we're back on the record. Mr. Fick, did you have a chance to go through that report with Mr. Trush?
Yes,
All right, Mr. Trush, are there any additions, deletions, or corrections to the report?
There's not, Your Honor. I do just want to make a clear record on that. Mr. Fick and I talked when the report came in. We talked again a few days ago. I don't remember if it was Monday or Friday of last week, but a couple days ago, we went through it again. I think the hearing kind of got off to a rocky start, and I think Mr. Fick was a little bit nervous when you asked him that question.
Okay.
But we had gone over the recommendations and what's contained in the report. We don't have any corrections, additions, or deletions.
Okay, good. Thank you for that clarification. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
All right, and as I indicated, I did receive the letter from Mr. Matera from Vesta Homes. I did have a chance to read that prior to the hearing today. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Briefly, Judge, this is a possession of methamphetamine as well as analogs, alpazole, and third and fourth felonies, perhaps it may be even greater concern, 6 and 7 controlled substance convictions as indicated in the defendant's adult record under numbers 1, 5, 6, 10, and 12. There is a recommendation of jail with 8 days credit. I think in light of the fact that this is a now 8th and 9th controlled substance, I think jail would be appropriate. I have no other comments for the court. Thank you, Your Honor.
Thank you, Mr. Trush.
Your Honor, I think the prosecutor's read on this is actually fairly accurate. As I went through the history, there's 13 entries in his criminal history section. 9 of the 13 entries, I think, would squarely fall in what I would consider substance offenses. So either possession of a substance or something directly tied to use of it. So like an OWI type offense. The remaining 4 offenses are what I would call substance adjacent. And they are the type of offenses that I think we typically see where when we start to kind of trace back the series of events, it often starts with somebody consuming a substance and then things start to get out of hand from there. And I think that if we look at Mr. Fick's history, it paints a very clear picture. I think the letter that was sent by his employer shows that he's a good employee. And I think he is a good and reliable employee when he is sober and in his clear mind. And I think that his criminal history paints a very clear picture of someone who struggles with substances. Even if we look at the offense here, I mean, what we have is an offense that is very small amounts. The methamphetamine amount is residue. And there's 2 pills of prazolone, 2 pills. I think that paints a clear picture of, again, usage, not anything more nefarious than that. And looking back at his history, again, I don't see anything here that suggests anything more than someone who has a use problem. Which is to say, there's nothing in his history that suggests that he's selling or delivering or, again, anything more nefarious than he's been caught using. I agree with the prosecutor. I think his history is getting to the point where we're kind of at the last stop here. I suspect that this is likely a county jail sentence. That's what the recommendation calls for, and that kind of feels like the right place for this. It would seem to me, if he's back in front of the court again, this court or a different court, it's probably looking at MDOC sanctions. Based on where his guidelines are now, that could happen today. Again, it doesn't seem the most likely scenario, but it could. I would suggest to the court that I think a blended sentence is appropriate. I suspect the court is looking at doing some upfront jail. Obviously, that's what the recommendation is. I think for Mr. Fick, he would strongly benefit from some treatment. I would suggest to the court a reasonable sentence, maybe to impose some jail, but give him an option to engage in treatment and potentially reduce that jail sentence by doing so. I think that would provide him a strong motivator to engage in the treatment. And frankly, I think that time is better spent in treatment in the jail. I think it's better for him. It's better for the community. When sober, he is a productive member of the community. So I would ask the court to consider that. Thank you.
Thank you, Mr. Fick. Anything you wanted to say today? I did read through the report, so I'm familiar with what happened in this case. You were before me, not too long ago on a very similar case. And in fact, your two arrests were almost exactly a year apart, June 25th, 2024 and June 28th of 2025. And both very similar circumstances. I agree with Mr. Trush. There doesn't appear to be any more substantial involvement with substances other than use. They've been small amounts. I mean, the circumstances were almost identical, other than one time you were riding a motorcycle and the other time you were operating a vehicle. Same officer, in fact, that conducted the stop. So very similar, very indicative, I think, as Mr. Trush indicated, of use type offenses. I did read through the letter from your employer. Based on that, it does appear that you're a good employee. I would have no reason to disbelieve what your employer would have to say about you. And so this is kind of that circumstance where at some point you're going to need to get help and stop using, because it looks like you have the potential of moving forward and making a living and working and doing all the things that regular, normal, productive members of society do. And this is getting in the way of that. And it has been for some time, obviously, based on your record. And I did review the prior sentencing hearing that we had before. I think I highlighted a lot of the same things again. And based on your prior, probation sentences, you've been on probation 6 prior times. It continues to be my view that further probation isn't going to be productive. It hasn't worked up till now. I don't think it's going to work. I think to the extent that you want to seek treatment, that's something that you're going to need to do on your own, because you want to stop ending up here in front of me in this courtroom getting yelled at for showing up late. And I hope that you get to that point. And if you don't, Mr. Trush is absolutely correct. I mean, the upper end of the guidelines here is 20 months in prison. And I don't think at your age and your station in life, you want to start going to prison. It's a that is going to be an absolutely detrimental thing for you and for any hope of recovery. So this really is your last chance to avoid that, because I think the next time your guidelines will be within a prison sanction. And whether it's me or a different judge won't have the option of probation or jail. That being said, your previous sentence was 6 months. I think of course, the court is going to sentence you to a higher sentence than that this time. I think a local jail sentence is warranted. I don't think prison is warranted based on the nature of the offense here. There isn't any aggravating factors here that I think would warrant a prison sentence at this point. But certainly, as you continue to offend, penalties get higher. And so the court is going to sentence you to 9 months of jail, straight jail in the Otsego County Jail. You have credit for 8 days served. That's, in the lower third of the guidelines. I think it adequately accounts for your past history as well as the offense in this case and the mitigating factors. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $136 state cost. That says to both counts to be served concurrent to each other. You do have, and I don't know what your status is now or where you're living, but I don't have an objection to immediate release to work camp. This is a nonviolent crime. I don't find that you present any kind of danger to public safety. And I think given the nature of this offense, there's no reason why work camp shouldn't be an option if you're otherwise eligible. So the court has no objection to doing all of that time as part of the work camp program. You do have the ability to seek an appeal of this sentence. Mr. Trush, can you have Mr. Fick acknowledge receipt of this appellate rights, please?
And Judge, did you want to, okay.
That's not my list.
Okay,
Thank you.
yeah.
March 4th, yeah, March 4th.
And then Mr. Rolla, there was, and Mr. Trush, this is a matter of record. There was some confusion about the plea agreement here. The amended information doesn't help clear that up. That's it.
I didn't look at that. Okay, yeah, if we can use that, if you want to.
So that would be counts 1 and 2 amended information.
Yes,
Okay.
yeah,
And you said the note indicates there was a F4.
Was a half.
Yes.
But it was amended down to a half.
Okay.
yeah,
So if we're good if we change it. There was a difference in what the original information indicated in the plea agreement. We needed to resolve that discrepancy.
yeah.
Correct, the court should have already received an amended information indicating that instead of 769.12, it's 769.10.
And then, yeah, they said count 3 was dismissed. There was not a count 3 originally.
Okay.
It looked like it was the enhancement, the second offense notice
Okay.
that was needing to be dismissed.
Okay.
instead.
So are we good
Yeah,
now?
I think, yep,
Okay.
with that amended information. Thank you.
Okay. Thank you, Mr. Fick. We're going to go with the officer this time. Mr. Trush, I have Mr. Alber connecting. Mr. Alber, are you able to hear me okay?
Sir,
All right, we're on the record in People versus Alber. This is file number 266962. Mr. Alber is appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
Thank you, Honor, Richard Trush, appearing on behalf of Mr. Alber. Aaron, this is date and time for our first status conference here in the circuit court. We're not quite to a resolution on this yet, although we're still working on it. I would suggest to the court, if we were to adjourn it 30 days, I think we would be in a pretty good position to either resolve the case via a plea or to start looking at trial dates.
Mr. Rolla, any objection to that?
No, Judge, there's an offer outstanding in count one without enhancements.
Mr. Alber, were you able to hear all of that?
I didn't hear the last part about the enhancements.
So Mr. Rolla, the prosecutor, was just making a record of what the current plea offer is. And that is to count one with the controlled substance enhancement and the habitual offender being dismissed.
Correct, Your Honor.
So you don't have to make that decision today, but Mr. Rolla wanted to make a record of that.
Okay.
Mr. Alber, do you have any objection to setting this case for a hearing in 30 days?
No, Your Honor.
All right, so I'm going to set this for a status conference and plea hearing in about 30 days. So Mr. Alber, between now and that next hearing, you need to make sure that you stay in touch with Mr. Trush. And at that next hearing, I'm going to need you to be ready with a final decision as to whether you want to accept that plea agreement or go to trial, okay?
Yes, Your Honor.
All right, Mr. Trush, anything further on this case today?
No, Your Honor.
Can I say something?
Yes.
Mr. Trush, I'm going to contact you today.
Okay, I'm gonna be in court for a lot of the day today. If you reach out, I might not get back to you till tomorrow or Friday, but I mean, feel free to reach out.
I'll call you tomorrow then.
Okay.
Thank you, guys.
All right. Thank you. That's all for this hearing. Mr. Alber, you're free to disconnect at this time.
Thank you. Bye.
Mr. Millsap, we have your hearing set for 10:15. I don't see your attorney joined in yet, but as soon as your attorney does, we'll get started with your case.
Okay.
Mr. Trush, is Mr. Slating present?
Your Honor, that was adjourned by stipulation. He has medical issues.
That's correct, Your Honor. As to the stipulation, I can't confirm as to his medical issues.
Okay. So our next two, we have Mr. Jones and Ms. Cornet. I believe they're going to bring Ms. Cornet up from the jail for her sentencing hearing. So
Mr. Jones is lodged in the jail as well.
and we're going to do that one by Zoom, I believe. Mr. Roll, I do have Millsap's attorney now signed in, so
Very good, Your Honor.
while we're waiting, we can proceed with that hearing.
That's fine.
We need Cornet brought up and Jones. Yeah. Mr. Baldori, are you able to hear me okay?
I am. Thank you so much. Yeah.
Okay, we're on the record now in People versus Millsap. This is file number 256912. We have Mr. Rolla present here in the courtroom today. We have Mr. Millsap present by video from Department of Corrections and his attorney, Mr. Baldori, by Zoom. This is set as a status conference here today. Mr. Baldori, I know this is your first appearance on Mr. Millsap's behalf. We did have a jury trial scheduled for March in this matter. The last hearing, Mr. Millsap was in the process, I believe, of retaining you. And so we had indicated for the record that we were going to adjourn that trial, just prospectively looking and suspecting that new counsel was going to want more time to be able to get up to speed in the case. So with that background, Mr. Baldori, can you tell me where you are at right now with this matter? And then we'll conduct some further scheduling here today.
Thank you. That is accurate, Your Honor. And if given the opportunity, I might like to speak with Mr. Millsap in a breakout room. But first, I'll address the court that yes, I did send in my appearance and request to the prosecutor's office. I think yesterday or the day before yesterday. I have some of the documentation discovery, but I don't have like the video discovery and so on. I can communicate with the prosecutor's office further in relation to that. I just want to make sure I have everything. And then, yes, yeah, just having some time to get through this, understand the parameters of this case, and then, yes, proceed to, having trial dates set. Not quite sure what I would request in terms of the timeline quite yet until I kind of get into the discovery a little bit more, but I can certainly leave it to the court to set those dates and just provide sufficient time for us to get a handle on the case.
All right, thank you. Mr. Rolla, I mean, I know you were probably gearing up for the trial, at least prior to the last hearing, but do you need an extensive period of time to be ready to go?
I do not, Judge. Again, if people have no objection to an adjournment in order to avoid a number of conflicts that would otherwise perhaps create appealable issues, 60 days, if the court wants to do that, might be appropriate. I'd also advise defense counsel, yes, our office did receive your appearance, so discovery materials are being sent out. As to the other videos and stuff, you'll probably receive also a response letter from our office indicating how you can obtain those copies, either from prior counsel or available directly from our office. And I would additionally indicate that there was added a plea offer that you would not have been aware of, perhaps that was extended back on in September of last year prior to trial, of an added count of criminal sexual conduct, first degree, multiple variables that would have, of course, taken away the 25-year mandatory minimum with the charges that are currently pending.
Okay,
Understood.
so Mr. Baldori, I would like to get this on the trial calendar. I have no problem, building in enough time for you to be prepared. But if the court were to set this, 4 to 5 months out, is that going to be enough time, or is that too much time?
I would appreciate that. Yeah, I'm pretty solid booked through certainly the rest of this month and a lot of April. But yeah, that's good. That gives me time to negotiate my schedule. And I will. So when prior counsel is referred to, I'm not quite sure. Mr. Millsap had been corresponding with Michael Mataloni's office. He has sadly passed away. I took over a certain number of his cases. I don't know what discovery. I'm not sure if what he had was comprehensive in regards to the discovery as to this case. So I do want to work with the prosecutor's office to make sure I have everything. And if I have to go out of my way to get some of these materials, I'm happy to do that. So that's just something we have to get to.
Okay.
And Judge, I would suggest a final status conference at least a month prior to trial. So that way defense counsel can confirm that they received all the discovery that they need in order to prepare for the trial.
Agreed.
Okay, so the court is going to set this about 4 months out for a 3-day jury trial. Mr. Baldori, it's typically my practice to set it for a final status conference about 30 days prior to the trial date. That status conference is the plea cutoff. So to the extent that Mr. Millsap wishes to further consider any plea offers, that final status conference will be the last date to enter into any pleas. Either side is free to file motions at any time, but the motion cutoff is also that final status conference. So any motions need to be filed and heard no later than that date. And Mr. Baldori, I'll send out a scheduling order that reflects those, as well as instructions on trial preparation. So you'll get a copy of that. with the dates that we've discussed here today.
Okay.
And then that's how we'll proceed. Mr. Baldori, anything else that I can address for your side here today?
I have nothing further on. I appreciate it.
Mr. Rolla?
Just for the benefit of defense counsel, if there should be some issue regarding discovery material, just contact our office manager, and we'll make sure that that's provided.
Thank you. And if the court, I'm not sure if the court can accommodate me on this. Is it possible for me to go into a breakout room with my client?
Yes, I can absolutely do that.
Okay.
Mr. Millsap, before we do that, do you have any questions about how we're going to proceed with your case?
I do not.
Okay. All right, I'm going to open that breakout room right now then.
Thank you, Your Honor.
All right, and then that will conclude that hearing, Mr. Baldori. Once you're done, and feel free to use as much time as you want. Just go ahead and disconnect.
Okay, very good.
Is the jail, the jail is informed that they should have Mr. Jones on Zoom, and then Mr. Cornet there will be bringing her ready to be brought up after that.
Okay.
Short staff.
See Mr. Jones.
Yes.
We'll go off the record for a few minutes. All right, sir, are you Luther Jones?
Yes, sir.
Okay. All right, we'll go on the record in People versus Jones. This is file number 266961. The record should reflect Mr. Jones is present today by video from Otsego County Jail. Oh, where's Mr. Rolla? Now I see what-
Oh, I'm sorry. I didn't know that back there. I think so.
Okay.
Okay, we have Mr. Rolla present. Mr. Rolla, we have Mr. Jones on the video. Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor. This is our first hearing here in circuit court. This case is progressing a little slower than our average case, I would say. However, there are some complicating issues to it. We spent more time than usual down in district court because there was an issue of an extradition with Texas and whether or not they were actually going to come and get him or not. We still have some issues, I think, to dive into and to figure out in regards to this. I'm going to ask for a little longer an adjournment than I normally do, just because I'd like to try to get to the bottom of these before we come back here. So I would suggest to the court, I think a 60-day adjournment would probably be appropriate. And would give us an opportunity to again get into those issues we need to get into.
Okay, Mr. Rolla.
Yes, Your Honor. In fact, my office has also been in contact with Texas and the defense PO in Texas. So they're aware of this situation. There was a plea offer that's on the record as to plea to counts 1 and 2 as a habitual second, for dismissal of counts 3 and 4 in habitual fourth. That offer was made by Ms. Brooker from our office, my chief assistant, back on January 28th of this year. The people have no objection to giving the defense more time. However, of course, this is not one that has anything, in any other situation, we don't want it overly delayed. This is a delivery of methamphetamine case.
Okay, Mr. Jones, were you able to hear all of that?
Yes, sir.
All right, have you talked to Mr. Trush about this 60-day delay in your case?
Yes, sir.
Do you have any objection to that?
No, sir.
Okay, all right, so Mr. Trush, we will set this for a status conference plea hearing in 60 days. I mean, at that point, is there any reason why you wouldn't be ready to enter into a plea agreement if there is going to be one?
I would expect at that point, we're likely to be able to move the case forward, whether that's with some sort of agreement, or if not, again, given the circumstances, we'd be looking to get on the trial track.
Okay, all right, thank you. Mr. Jones, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay, all right, thank you. That concludes this hearing today, and the court's going to disconnect from the jail. Ms. Cornet, if you go up to the podium there, please. We'll go on the record in People versus Cornet. This is file number 256943. The record should reflect Ms. Cornet's present here in the courtroom today. This is the date and time set for sentencing hearing in this matter.
I'm going to have her sit at council table since I think we have a victim that
Okay,
I expect is going to allocate.
all right. Ms. Cornet, have you had an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, I have.
Okay. Mr. Trush, are there any additions, deletions, or corrections?
We did have just one. That is on CFJ 284. The very last sentence of the first paragraph indicates that she has no relationship with her family at present. She reports to me that actually since the PSI interview, she has rekindled contact with her parents.
Judge, we have no problem with that addition being at PSI.
Okay. The court will have that correction made. Any other corrections?
No,
Are there any challenges to the scoring?
no, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
No, Your Honor.
And I did receive a letter from the victim's mother, Ms. Brooks. I had a chance to review that letter as well as the victim impact statement that was prepared. And also contains statements from Ms. Brooks. Mr. Rolla, do you have any victims that wish to address the court here today?
I have victim present, but at times that she's not going to give an oral statement at this time. That's one of the things I was discussing with her during the break. Thank you, Judge.
All right, anything on behalf of the people for allocation?
Yes, Judge. It's a situation where it's a first felony. As indicated by the victim in his victim impact statement, and it's also as indicated in the police reports, this defendant was both high and drunk, apparently at the time of this incident. PSI indicates a PBT result of 0.158, and the defendant openly admitted using marijuana twice daily, which she claims, and I quote, does not impair her motor functions, end of quote. With all due respect, in light of the facts in this particular case, not only because of the driving, but then after the incident occurred in which a person was injured, the defendant, because of hopefully what she was taking and under the influence of, as opposed to her general demeanor, went over to the victim, kicked him, and then said, oh, you're not that badly hurt, and then drove away. One would not, I would hope, normally do that if one were not under the influence of some substance or substances. The defendant in this case is very fortunate that we're not here, as is the victim and their family, on what would have been a homicide, because that very easily could have occurred. It's also a situation where this court needs to make sure that since the defendant up to this point in time has not in any way taken seriously her substance abuse issues, that this court needs to impose a sentence of incarceration and other matters to bring this point home, not just to the defendant, but to others who may want to consider acting the same way in the future. In addition, and our office was just advised of this, the victim is still suffering additional matters, and apparently, according to his mother, they had some x-rays done. There may be some additional surgery. And if that's required, he'll have to have the ankle rebroken to have it reset again, because there's apparently some calcification on the bone ends where the injury occurred. So as to that situation, the court would ask, the people would ask the court to order that the order indicate that there be a reimbursement for any out-of-pocket expenses to the victim or his mother arising out of this from up to this point in time, and then to the future arising, continuing out of this. I would also indicate that it's my understanding that at the time of this accident, the defendant also chose to operate her vehicle without insurance, so there's not an insurance carrier that could otherwise perhaps cover the injuries or damages in some part, if not in total in this matter. I'd ask the court to include that in any sentence to be imposed. Thank you, Your Honor.
All right, thank you. Mr. Trush, if you and your client can return to the podium, please. And Mr. Trush, anything for elocution on behalf of your client today?
Yes, Your Honor. We were here about 2 weeks ago for the initial sentencing date. What a difference 2 weeks, I think, makes here. I think many of the prosecutor's points, not all of them, many of them I think are very well taken. And I think that it is accurate that when we were here 2 weeks ago, I don't think Ms. Cornet had recognized or accepted sort of the extent of her problem. I am happy to report to the court when I went and met with her in the jail afterwards, and as we prepared for this hearing, what I was hearing from her was very different. She openly acknowledged to me that she has a problem with alcohol. I mean, confided in me that may have been the first time she was able to say that out loud, to really express it. She has expressed to me a desire to go into treatment and explore treatment. She's made contact with Bear River. This is a very unique case for us in the sense of we have somebody who presents here with no prior history, no history. And I mean, no prior felonies, no prior misdemeanors prior to this point. And then we have an offense that is frankly a pretty serious offense, more serious than we see most people, again, on what will be a true first offense. I think there is some unpacking that needs to be done here. I'm happy to hear from Ms. Cornet that she is wanting to seek treatment. I think we probably need to have an assessment done to figure out what the right level of treatment for her is going to be. But I think that is a very encouraging development that's happened in the last 2 weeks. And frankly, I don't know that happens if we don't sort of have the events that lead to it, which frankly are kind of, I think, a blessing in disguise that she was able to make that recognition. With that in mind, I think the court has to balance a few things in crafting a sentence here. And the first of which is, again, true first offense. But on the other hand, we have an offense that, again, I think is more sort of shocking and more serious than our typical offense. So the court has to balance, where do we fall on this? There's probably a punishment element, but I think certainly a rehabilitation element is an important element when we're looking at someone, again, Ms. Cornet's stage of life who really has no prior history. We have to balance those things. And certainly we have to balance the impact that this has had on the victim and the victim's family. I think for the court, I would suggest that a sentence here that focuses on rehabilitation is the appropriate goals here. I would suggest to the court, there's a few different ways I think the court could address that. I spoke to Ms. Cornet. She would be willing and actually is interested in the court placing her on a tether if the court were to allow for her to be released from the jail. I think that would be a good step for her. She's also expressed to me, she does have employment. So if the court were to allow her to partake in the work camp program, participate in that, she has a job that she could go back to. The work camp program, I do think, has benefits that would be specifically beneficial in this case. Specifically, she would be tested every day, meaning, as opposed to even sort of a regular probationary term, where she wouldn't be tested every day. If she were in the work camp program, she would be tested and held accountable every day. And if she relapses and uses, she's going to go right back into the jail. So I think that there are tools the court has here in terms of what we can do to craft a sentence that has both a punishment element to it, but also focuses on the goals of rehabilitation. Thank you.
Thank you, Ms. Cornet. Anything you wanted to say today?
Sure. First, I would like to apologize to Hayden and his family. My actions and lack of action that night were inexcusable. I'm so sorry for the pain that I caused, and I wish that your family didn't have to live through that pain. I wish I could go back and do the right thing for you, and I will forever be sorry for this. Your Honor, I also want to apologize for the state that I was in the last time that I was here. I was drinking the night before, and I do understand why you made the decision that you made that day. But along with my apology, I also want to thank you for making that decision. Even though in that moment I was confused, scared, and angry, I have to say thank you because you helped me. My head is more clear and I'm thinking straighter than I have in a long time. While I was away, I met a woman who I became friends with. And this woman is coming to the end of a very long sentence due to repeat offenses. She opened my eyes as to where the road I've been taking the last 5 months will lead, should I continue on it. I attended the women's group, which helped me open up and be honest about my issues and my alcohol abuse. It also helped me realize that it's not too late to change. Last Friday, I was able to speak with a therapist from Bear River and get information about treatment programs. I know that people don't change overnight, but I have started to change. I've never been one to ask for help, and I realize now that I need help, and it's getting easier to ask. I have 5 kids who I need to mend relationships with. I am so proud of the people that they have become and are becoming. And I was always proud of my role in helping them become these people. While I'm still so proud of them, I'm no longer proud of myself. I want to be able to be proud of being a mom again. I am so sick of being a disappointment to them, and I want to do better. Along with all of this, in January, I was hired by Dollar General to be the store manager, and they're waiting for me to let them know when I can start. My parents instilled a very strong work ethic in me from a young age, and I am excited and hopeful about this opportunity. I'm extremely serious about my recovery and the recovery of my life, and I'm willing to do whatever it takes to ensure this. Thank you.
All right, thank you. Ms. Cornet, I did read through the report. I'm familiar with what happened in this case. There's also a lot of information in that report about you and your circumstances and your background. I take all of that into consideration. I certainly take the victim's statements into consideration. That's something that's important for the court to recognize the effect that the crime has had on the young man in this case and his health and problems that he's going to have going forward because of this injury. And the effect that it's had on their family generally. These things don't happen in a vacuum. And when you're the victim of a crime, it creates all kinds of issues in terms of feeling safe, feeling secure. And that's aside from just dealing with an injured child and the medical appointments and concern over the long-term effects and how it's going to affect his life. So their statements certainly have an impact. I've listened carefully to what the lawyers of each had to say, and of course, what you've had to say here today. That's important to me. And I think that it is certainly promising that you're starting to kind of get a different perspective on the way things were going. I think it's clear from your statements and actions leading up to your last appearance in court, at least, that you did not fully see the other side of this. And I think that's in large part due to your use of alcohol and marijuana and other substances, perhaps. When you're in the middle of that, you can't really see what everybody else sees looking at it from the outside. And, you know, your actions around this crime, using marijuana and driving, and then saying, well, it doesn't really affect me. Well, if it doesn't affect you, why are you using it? The whole reason why people use marijuana is because it alters their mental and physical state. It makes them feel better, makes them feel different. And so it doesn't make any sense to say I'm using marijuana, but it doesn't affect me. And clearly, you know, you were using alcohol. I know your statement was that you started drinking after the accident happened because you were upset. Given the full development of everything that's happened during this case, I don't believe that either. I'm firmly convinced that you were using alcohol before you were driving, and that and the marijuana contributed both to the accident and the injury of this young man and to your actions in leaving the scene, all of which complicated this and puts you in a worse position. Certainly delayed the help that the young man could have gotten and should have gotten. That being said, you know, you don't have a prior record. It sounds like you want to take steps to address what you now see as a problem. And so the court has to take those things into consideration along with the negative aspects. And I think a sentence that combines some punishment so that you understand that this was wrongful conduct, that it doesn't just go away, that there are other people who are going to feel long-term effects as a result of this. And so it's right that you feel some effects as a result of this. I also think that providing for probation to monitor you once you are released from jail is important for us as a community, to make sure that once you get on the right track, that you're staying on the right track, so that you're not presenting a danger to other people by using marijuana or alcohol. And then I think the allowance for rehabilitation is also important, because you don't have a prior record. I think you've demonstrated that you can conform to what we all expect, and that you can get back to that and move on from this and not present a danger to other people. So I think it's important for the sentence to try to incorporate all of those elements. So in that regard, first of all, the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. And that includes, of course, that you not use alcohol, that you not possess alcoholic beverages or other intoxicants, that you not use or possess any controlled substances or drug paraphernalia unless they are medications that are prescribed to you, that you complete any outpatient or residential substance abuse treatment that's referred to you by your probation agent, and all the other terms and conditions of the probation. The court is going to order that you serve 9 months in the Otsego County Jail. The court is going to require that you serve 6 months of that up front. I would allow you to be released for the remaining 90 days if you are able to get a bed and go into residential treatment. So I would allow you to leave jail for the purpose of attending a residential treatment program only. That's a 30-day program, 60-day program, whatever it is. If you successfully complete that program, then the court would give you jail credit for that program off your sentence, and whatever would be remaining of that final 90 days would be held in abeyance. So again, 9 months in the Otsego County Jail, the first 6 months will be served up front with released to residential treatment if eligible for the last 90 days. If you're not able to get into a residential treatment program, then you would just have to serve that final 90 days in jail. Do you have credit for, what was the date of our last hearing?
Should be 17 days total, so
17.
15 additional days.
Okay, so you do have credit for 17 days served. Court is also going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and a $68 state cost, as well as a $30 supervision fee per month while you're on probation. You do have the ability to seek an appeal of the sentence, and Mr. Trush, if you can have Ms. Cornet down with receipt of her appellate rights.
Yes, sir.
Judge, is the court going to make a finding on the record as to restitution to the victim?
Thank you. That wasn't in there. The court is going to leave the matter of restitution open. Mr. Rolla, as you're aware, the people have the obligation of supporting the request for amounts for restitution. So I'll leave that open to the extent there is restitution. I think certainly it would be appropriate in this case, and the court will order it. You'll just need to notify counsel if there's an objection, then you would need to notice that for hearing so the court can take evidence as to the.
And that's fine, Judge. We're awaiting some additional documentation. So restitution is preserved.
Yes.
Thank you, Your Honor.
All right, has Ms. Cornet received her appellate rights?
She has initialed and dated acknowledging she's received them. I'm tendering that back to the court.
All right, thank you, Ms. Cornet. You are remanded to the custody of the county.
Your Honor, does the court want me to prepare an order in regards to the rehab treatment?
I made as part of the jail worksheet, they're aware that she is eligible to be released after 6 months to treatment. Once we get to that point, we may need, in order if she's able to get that and get into treatment.
Understood.
Your Honor, would I be able to hug my husband before I go back?
I'm sorry, no.
Love you.
Mr. Roll, I believe that's.
The end of the docket, I hope so.
All right, the court will be in recess until 1:30.
In this powerful courtroom moment, everything changes when a defendant finally takes responsibility, not just for her actions, but for the damage they caused. She stands before the judge, apologizing to the victim and his family, admitting her struggles with alcohol, and promising to change. It's raw, emotional, and real. The court listens carefully, but doesn't ignore the facts. The judge makes it clear that her choices, driving under the influence and leaving the scene, caused serious harm to a young victim and long-term pain for his family. But then comes a balanced decision. Instead of only punishment, the judge combines consequences with a path forward. 18 months probation, 9 months in jail, and a chance to leave early for rehab. It's not just a sentence, it's a wake-up call. As she's taken back into custody, she asks for one thing: to hug her husband goodbye. The judge says no. And just like that, reality hits. In court, regret comes late, but consequences come right on time. Like and subscribe for more real courtroom moments.